March 6, 1857. An enslaved man named Dred Scott stands in the United States Supreme Court to hear if he's human or property. Chief Justice Roger Taney speaks for 2 hours. His answer will kill 750,000 Americans in the war that follows. This is how one lawsuit destroyed a nation. Southampton County, Virginia, 1795. A child is born into slavery on Peter Blow's plantation. They named him Sam. Decades later, he will take the name Dred Scott and shake the foundations of America. The Blow family moved west in 1830, dragging their human property to St. Louis. Peter Blow dies broke. His daughter Elizabeth sells Sam to Army surgeon Dr. John Emerson for $500. This sale will echo through history. Dr. Emerson serves at Fort Armstrong in Rock Island, Illinois. He brings Scott with him. Illinois is free soil. Its Constitution declares, "Neither slavery nor involuntary servitude shall hereafter be introduced." For 2 years, Dred Scott lived where slavery could not legally exist. He says nothing. Not yet. 1836. Fort Snelling, Wisconsin Territory, modern-day Minnesota. Even further into free territory, where the Missouri Compromise of 1820 explicitly bans slavery north of 36°30°E. Here, Scott meets Harriet Robinson, enslaved by Indian agent Lawrence Taliaferro. Taliaferro, acting as justice of the peace, performs their marriage ceremony. The paradox stuns: a slave owner legally marrying 2 people he claims aren't legally human. Dr. Emerson was reassigned to Louisiana in 1837. He leaves the Scotts hired out at Fort Snelling for months. An enslaved person on free soil, hiring out his own labor, collecting wages. The contradiction builds. Emerson returns, takes the Scotts down the Mississippi to Louisiana, then back to St. Louis. They have traveled 5,000 miles together. Daughter Eliza is born on a steamboat between free and slave territory in 1838. Lizzie follows in 1840. Dr. Emerson died in 1843. His widow Irene inherits the Scotts. She hires them out for wages she pockets. April 6, 1846. Dred and Harriet Scott walk into the old courthouse in St. Louis. With them is Francis Murdoch, a lawyer who posts their bond. They file 2 petitions, one for him, one for her. The legal argument is simple. Prolonged residence on free soil equals emancipation. Missouri courts have upheld this principle 30 times before. Rachel v. Walker, Winnie v. Whitesides. Clear precedent. Dred Scott cannot read or write. He signs his petition with an X, but he understands exactly what he's doing. He's claiming something revolutionary, that a black man can use white law to make himself free. The Blow children, now grown, remember their childhood playmate. Taylor Blow pays the filing fees. Charlotte Blow's husband testifies. They know what their father never admitted. Some sins demand correction. Scott is 51 years old. He assumes this will take months, maybe a year. Missouri law seems clear. He has no idea he's just lit a 15-year fuse that will explode at Fort Sumter. June 30th, 1847. The first trial begins in a St. Louis courthouse basement, windows at street level, horses' hooves clattering past. Dred Scott sits at the plaintiff's table in a borrowed suit. Across from him, Irene Emerson's lawyers argue property rights. The case should be simple. Prove he lived on free soil. Prove Emerson took him there. Freedom follows. But technicalities kill him. The witness who could prove Emerson owned Scott when they lived at Fort Armstrong doesn't appear. Hearsay rules exclude critical testimony. Verdict: remain a slave. His lawyer files for a new trial. Judge Alexander Hamilton, yes, that's his real name, grants it. Irene Emerson's lawyers panic. They appeal to the Missouri Supreme Court, trying to block the retrial. The appeal fails. Meanwhile, Scott lives in legal purgatory. The sheriff of St. Louis holds him in custody, which means hiring him out and holding his wages in escrow. Scott works as a janitor, a porter, whatever pays. His daughters grew up watching their father mop courthouse floors while fighting for their freedom in its chambers. February 1850. The second trial. This time, witnesses appear. Military officers testify about Fort Armstrong and Fort Snelling. The jury deliberates for 15 minutes. Verdict: Dred Scott is a free man. For 12 brief months, the Scott family tastes freedom. Harriet works as a laundress. Dred takes odd jobs. They save every penny. But Irene Emerson appeals to the Missouri Supreme Court. The political climate has shifted. The Compromise of 1850 inflames Southern paranoia. Northern abolitionists grow louder. Missouri, once moderate, hardens. March 22, 1852. The Missouri Supreme Court reverses Scott's freedom 2-1. Judge William Scott, no relation, writes the majority opinion. He acknowledges that Missouri had repeatedly freed slaves taken to free states. Then he declares, "Times now are not as they were." Translation: the political winds have changed, so the law must change too. Judge Hamilton dissents furiously. He calls the decision a purely political decision that overthrows 30 years of precedent. But dissents don't free anyone. The Scotts are enslaved again. Worse, they now owe back wages for the years they lived free. Hundreds of dollars they don't have. Meanwhile, Irene Emerson remarries. Her new husband is Dr. Calvin Chaffee, an abolitionist congressman from Massachusetts. The irony is excruciating. She transfers ownership of the Scotts to her brother, John Sandford, living in New York. This changes everything. A Missouri citizen suing a New York citizen. Federal diversity jurisdiction. A path to the Supreme Court opens. May 15, 1854. Dred Scott versus John F. A. Sandford begins in federal court. The clerk misspells Sandford's name as Sandford. The error immortalizes itself in history. Judge Robert Wells presides. Sandford's lawyers raise a new argument. Scott cannot sue because he is not a citizen. Black people, they argue, can never be citizens. Wells instructs the jury to decide only if Scott is free or a slave. The jury rules, slave. Scott's lawyer files for an appeal. December 1854. The United States Supreme Court agrees to hear the case. 8 years have passed since that first petition. Scott is nearly 60. His daughters are teenagers who have never known legal freedom. But the highest court in the land will now decide their fate, and everyone else's. The shift to federal court transforms everything. This is no longer about one man's freedom. Montgomery Blair, son of political titan Francis Preston Blair, takes Scott's case pro bono. He understands the stakes. Blair files his brief in February 1856. The questions before the Supreme Court multiply like a virus. Can a black person be a citizen? Can a citizen of one state sue a citizen of another? Did residents in free territory liberate Scott? Can Congress prohibit slavery in territories? Is the Missouri Compromise constitutional? That last question, nobody asked it. The court raises it themselves. John Sandford hires the best lawyers money can buy. Senator Henry Geyer of Missouri. Reverdy Johnson, former Attorney General. They argue black people were property in 1787, property in the Constitution, property forever. The legal briefs reveal the true battle. This isn't Scott v. Sandford. It's freedom v. slavery. North v. South. The future of Western territories hangs in the balance. Kansas bleeds as they argue. Pro-slavery forces massacre abolitionists at Pottawatomie Creek. The town of Lawrence burns. Senator Charles Sumner was caned nearly to death on the Senate floor for denouncing slavery. The country tears itself apart while 9 justices ponder. The Supreme Court in 1856 was stacked. 5 justices are from slave states. Chief Justice Roger Brooke Taney, 79 years old, from Maryland. A man who freed his own slaves but believes black people have no rights that whites must respect. Justice Peter Daniel from Virginia refuses to travel north of the Mason-Dixon line. Justice John Campbell from Alabama, who will resign to join the Confederacy. Justice James Wayne from Georgia. Justice John Catron from Tennessee. The Northern justices include Benjamin Curtis from Massachusetts, the court's most brilliant legal mind. John McLean from Ohio, who has presidential ambitions. Samuel Nelson from New York. Robert Greer from Pennsylvania. February 11-14, 1856. First arguments. The tiny Supreme Court chamber in the Capitol basement is packed. Senators' wives fan themselves in the gallery. Reporters scribble frantically. Montgomery Blair argues for 3 hours. He stays narrow. Missouri law freed Scott. Federal courts must respect state law. Don't touch the constitutional questions. Just free this one man. Reverdy Johnson responds with constitutional thunder. The Founding Fathers never intended black people as citizens. The Constitution protects property. Slaves are property. Congress cannot steal property by geography. The justices whisper among themselves. Something is wrong. They order a re-argument, highly unusual. They want the constitutional questions addressed fully. President-elect James Buchanan panics. He writes secretly to Justice Catron, his old friend, then to Justice Greer. He begs them to issue a broad ruling, settle the slavery question forever, take it out of politics, let the court save the nation from civil war. This is grossly improper. A president influencing a pending case. But Buchanan is desperate. The Democrats are splitting. The Republicans are rising. The court could solve everything with one decision. December 15, 1856. Re-argument. This time, everyone knows the stakes. The lawyers abandon restraint. This is about the Constitution's meaning, about whether the Declaration of Independence applies to black people, about whether slavery follows the flag forever. Senator Geyer argues the territories belong to all states equally. Southerners have the same right to bring property, human property, west as Northerners. The Missouri Compromise violated this equality. Blair counters desperately. The founders hated slavery. They expected it to die. The Northwest Ordinance banned it. Congress has always regulated territories. Justice Curtis asks pointed questions about citizenship in 1787. Free black men voted in 5 states when they ratified the Constitution. How can voters not be citizens? The lawyers finish. The justices retreat to conference. What happens next will take 3 months and destroy the court's reputation forever. January 1857. Behind closed doors in the Supreme Court's conference room, 9 justices argue as the nation argues. Chief Justice Taney chairs with an iron hand despite his frail frame. He wants a sweeping decision. No compromise, no ambiguity. Settle slavery forever. Justice Nelson writes a narrow opinion. Missouri law governs. Scott remains enslaved. Nothing about citizenship or territories. Several justices agree. Then Justice Curtis announces he will dissent. If the majority goes narrow, he'll go broad. He'll argue black citizenship. He'll defend congressional power. He'll attack slavery's expansion. The Southern justices explode. If Curtis writes that dissent, They need a broader majority opinion to counter it. Wayne and Daniel pressure Taney. Go all the way. Declare the Missouri Compromise unconstitutional. Establish that black people can never be citizens. Justice Greer wavers. He's from Pennsylvania, but sympathetic to the South. President Buchanan's letter arrives on February 23rd. Your Pennsylvania friends desire to know whether you concur with the majority. The improper pressure works. Greer joins Taney's broad opinion. Taney writes feverishly through February. 55 pages of dense legal argument. He goes beyond anything the case requires. He wants to settle not just Scott's fate, but slavery's future. February 19th, 1857. Justice Catron writes to Buchanan. The decision will cover all questions. It will declare the Missouri Compromise void. Buchanan is elated. In his inaugural address on March 4th, he hints that the court will soon settle the territorial question. Everyone should accept it cheerfully. The justices know the stakes. Justice Campbell writes to his brother. The court will make a decision that will be final. Justice McLean tells friends the majority has gone mad. Curtis considers resigning before the decision is even announced. March 4th, 1857. Buchanan's inauguration. Taney administers the oath. They shake hands on the Capitol steps. Observers notice them whispering. The fix is in. March 5th. The justices take their seats. Tomorrow they will announce. Taney has his opinion. Nelson has his narrow concurrence. Curtis and McLean have their dissents. 6 other justices write separate opinions. 9 opinions total. The most in Supreme Court history. That night, Dred Scott sits in a boarding house room in St. Louis. He cannot read the newspapers predicting his fate. He's 62 years old, 11 years in courtrooms. His wife, Harry, prays beside him. Their daughters, Eliza and Lizzie, now young women, wait. Across the city, artillery units polish their cannons. If Scott wins, they expect riots. If he loses, they expect celebrations. Either way, they expect violence. In Washington, reporters sharpen their pencils. Telegraph operators clear the lines. This will be the most important Supreme Court decision since Marbury versus Madison. Frederick Douglass writes in his journal, "Tomorrow, the Supreme Court will tell us whether a black man has any rights in America." Abraham Lincoln, a lawyer in Springfield, Illinois, reads the preliminary reports. He tells his partner, William Herndon, "If the court decides against Scott, it will transform our politics forever." March 6, 1857, dawns cold and clear. The Capitol's basement courtroom fills before 9 a.m. Senators abandon their chamber. Congressmen crowd the aisles. Women in hooped skirts pack the gallery. Everyone understands they are witnessing history. At exactly 11 a.m., the marshal cries, "Oyez! Oyez! All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting." Chief Justice Roger Brooke Taney rises, 79 years old, cadaverous, voice barely above a whisper. He holds his opinion in shaking hands. 2 hours. He will speak for 2 hours and change America forever. Taney's voice cracks as he begins. The question is simply this: can a Negro, whose ancestors were imported into this country and sold as slaves, become a member of the political community? The packed courtroom leans forward. Taney continues, voice gaining strength. We think they cannot. The words people of the United States and citizens are synonymous terms. The question before us is whether the class of persons described is constituent member of this sovereignty. We think they are not. Gasps from the gallery. Taney raises his hand for silence. For the next hour, he rewrites American history. He claims that at the nation's founding, black people were regarded as beings of an inferior order and altogether unfit to associate with the white race. They had no rights which the white man was bound to respect. This is a lie. In 1787, free black men voted in Massachusetts, New Hampshire, New York, New Jersey, and North Carolina. Taney knows this. He doesn't care. He continues. The Declaration of Independence's words, "All men are created equal," never included black people. The founders never intended them as equals. They were property then. They are property now. They will be property forever. Senator Charles Sumner, still recovering from his caning, stands and leaves. His departure echoes through the silent chamber. Taney moves to the territorial question. The Missouri Compromise, he declares, is unconstitutional. Congress has no power to ban slavery in territories. The Fifth Amendment protects property. Slaves are property. Therefore, banning slavery violates due process. The Southern senators smile. This is more than they dreamed. Taney continues relentlessly. Even if Scott had become free in Illinois, which he didn't, returning to Missouri re-established his slavery. Missouri law governs. Federal courts must accept it. Furthermore, Scott had no right to sue in federal court. He is not a citizen, can never be a citizen. No black person, free or slave, can ever be an American citizen. 2 hours. Taney speaks for 2 excruciating hours. When he finishes, he slumps in his chair. Justice Wayne rises, reads his concurrence, then Campbell, then Daniel, each one piling on. Black people are property. We're always property. We'll always be property. Justice Nelson reads his narrow opinion. He would have decided on Missouri law alone, but he concurs in the judgment. Justice Greer concurs. The pressure from Buchanan worked. Then Justice McLean rises. His dissent burns with fury. Being born under our Constitution and laws, no naturalization is required to make citizens of those born on our soil. He attacks every point of Taney's opinion. Free black men voted. They served in the Revolution. They were citizens then. They are citizens now. Justice Curtis stands last. For an hour, he demolishes Taney with facts. At the Constitution's ratification, free black men were citizens in 5 states. They voted for the Constitution. How can those who voted to create the government not be citizens of it? He proves Taney misrepresented history. The Northwest Ordinance banned slavery. The Missouri Compromise followed precedent. Congress has always regulated territories. The courtroom is spinning. 9 opinions, 2 days to read them all. But the outcome is clear. 7-2. Dred Scott remains a slave. His wife remains a slave. His daughters remain slaves. And no black person in America has any rights that a white person must respect. The telegraph wires burn with the news. Within hours, it reaches every major city. In Boston, abolitionists weep openly. In Charleston, cannons fire in celebration. In Springfield, Abraham Lincoln reads the decision and tells Herndon, "The Republic is dead." That night, Dred Scott received word in St. Louis. He doesn't cry. He doesn't rage. He simply nods and says, "I expected it." Harriet holds their daughters as they sob. 11 years. 11 years of hope destroyed in 2 hours. But in New York, Frederick Douglass stands before 3,000 people and roars, "My hopes were never brighter than now." The crowd stares in confusion. He explains, "This decision, infamous as it is, will be a blessing. The Supreme Court has made the path clear. There can be no compromise with slavery, no middle ground. This decision will wake the nation to what slavery truly is. He's right. Taney thinks he's settled the slavery question forever. Instead, he's guaranteed civil war. Justice Benjamin Robbins Curtis doesn't sleep the night of March 6th. He writes through dawn, preparing his dissent for publication. It will cost him everything. Curtis is 47, brilliant, and the only justice with a Harvard law degree. He knows Taney's opinion is not just wrong, but dangerous. His dissent runs 70 pages, a systematic demolition. First, citizenship. Curtis provides receipts. In 1787, free black men were citizens in Massachusetts, New Hampshire, New York, New Jersey, and North Carolina. They voted. They held property. They served on juries. North Carolina's Constitution explicitly gave free black men the vote until 1835. He quotes state constitutions, court records, voting rolls, undeniable proof that black citizens existed at the founding. Taney claimed black people were universally degraded in 1787. Curtis proves otherwise. Massachusetts had banned slavery. Pennsylvania was gradually abolishing it. Free black communities thrived in Philadelphia, Boston, and New York. The knockout blow. Free black sailors carried American passports. The State Department issued them. These passports declared them citizens of the United States. How can the federal government issue citizenship documents to non-citizens? Curtis then attacks the territorial argument. He lists every territorial regulation Congress ever passed. The Northwest Ordinance of 1787, passed by the same men who wrote the Constitution, banned slavery. If the founders thought Congress couldn't regulate slavery in territories, why did they do exactly that? The Louisiana Purchase Treaty promised to protect property, but it also gave Congress power to make needful rules. Congress banned the slave trade in the Louisiana Territory. Nobody claimed that was unconstitutional. Justice McLean's dissent takes a different approach. He argues morality. Slavery is emphatically a state institution. It exists only where positive law creates it. The moment a slave leaves that jurisdiction, freedom is the default. McLean cites Somerset versus Stuart from England. The moment a slave touches free soil, chains fall away. This was established law until today. Both dissenters predict disaster. Curtis writes, "When a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, the theoretical opinions of individuals are allowed to control its meaning. We no longer have a constitution. We are under the government of individual men." McLean is blunter. This decision will be the Dred Scott decision. A self-inflicted wound which will fester and possibly prove fatal. The dissents circulate immediately. Northern papers print them in full. Southern papers bury them. Justice Curtis goes further. He obtains proof that Taney inserted new arguments into his published opinion that he never read from the bench. Taney added paragraphs after the decision, responding to Curtis's dissent. This is judicial fraud. Curtis writes to his brother. The Chief Justice's opinion was thus made to appear more complete than it actually was when delivered. He confronts Taney directly, demands the original manuscript. Taney refuses, claims it's his private property. April 1857. Curtis sends a letter to President Buchanan. He resigns from the Supreme Court. After just 6 years. At the height of his career, his resignation letter leaks. "I cannot remain where the Chief Justice manufactures opinions after the fact." Northern newspapers explode. The New York Tribune. Justice Curtis has exposed the corruption at the heart of our highest court. The Chicago Tribune. 7 justices have disgraced their robes. Southern papers defend Taney. The Charleston Mercury. Justice Curtis flees because he cannot accept the Constitution's true meaning. But private letters reveal deeper concerns. Senator William Seward writes, "The Supreme Court has committed suicide." Former President Millard Fillmore. Taney has destroyed the court's moral authority. Even some Southerners worry. Alexander Stephens, future Confederate Vice President, writes privately, "The decision goes too far. It will create more abolitionists than Harriet Beecher Stowe." The legal community is horrified. Every law school in the North condemns the decision. Harvard Law Review publishes a special issue dismantling Taney's reasoning. State Supreme Courts rebel. Ohio's Supreme Court declares, "The Dred Scott decision is not binding on state courts." Maine follows. Then Vermont. Wisconsin's Supreme Court goes furthest. The Supreme Court has no authority to impose slavery on free states. The dissents become ammunition. Republican politicians read them at rallies. Abolitionists print them as pamphlets. Frederick Douglass calls Curtis the one honest man on a court of scoundrels. But the damage is done. The highest court in the land has declared black people subhuman. Forever. No constitutional amendment exists to override them. The only solution is political. Or military. March 7, 1857. The morning after. Northern newspapers arrive at doorsteps with headlines like war declarations. The New York Tribune. The decision of the Supreme Court is the moral assassination of a race. The Independent. If the people obey this decision, they disobey God. Boston's Liberator. The Taney decision is the most atrocious crime in the judicial annals of the Republic. Mass meetings erupt spontaneously. In Faneuil Hall, 5,000 Bostonians roar as Wendell Phillips declares, "The Supreme Court has dragged the Constitution through the filth of slavery." In New York's Tabernacle, 3,000 pack the pews. The Reverend Henry Ward Beecher thunders, "The slave oligarchy has captured the Supreme Court. Will we let them capture the nation?" But the most electric response comes from Frederick Douglass in Philadelphia. Before 4,000 people, he makes a prediction that chills Southern spines. This decision, infamous as it is, will prove a blessing. The Supreme Court has made it clear. The Constitution is a slave document. Therefore, we must have a new Constitution or no Constitution. This government must be abolished or made anew. The crowd erupts. Some weep, some cheer. Many leave to buy guns. The Republican Party, just 3 years old, seizes the moment. William Seward writes the party's response. The Supreme Court has descended from its dignity into the political arena. It represents not justice, but the slave power. State legislatures go to war with federal law. Vermont passes a freedom law. Any slave brought into Vermont is automatically free. Maine follows. Then New Hampshire. Wisconsin goes furthest. Its legislature declares the Fugitive Slave Act void. When federal marshals arrive to arrest an escaped slave named Joshua Glover, a mob storms the jail and frees him. The Wisconsin Supreme Court backs the mob. Ohio Republicans introduce legislation to ban any slaveholder from entering the state. Michigan proposes stripping federal courts of jurisdiction over freedom suits. The Underground Railroad explodes with activity. Conductors report a 300% increase in escapees. The slaves have heard. The highest court says they have no rights. So they take them. Northern churches split from Southern denominations. The Methodist Church breaks in half. Then the Baptists. Then the Presbyterians. In Brooklyn, Reverend Theodore Parker tells his congregation, "I would rather see my church burn to the ground than recognize the Dred Scott decision as legitimate law." Northern universities rebel. Harvard Law School holds a symposium, The Constitutional Crisis of 1857. Every speaker condemns Taney. Yale follows, then Columbia. Free black communities respond with rage and resolve. In Philadelphia, the Vigilance Committee arms itself. In Boston, black ministers preach self-defense. In New York, David Ruggles organizes the Committee of 13 to protect fugitives by any means necessary. White abolitionists become more radical. John Brown reads the decision in Iowa. He tells his son, "The Supreme Court has declared war on freedom. So be it. I accept their declaration." He begins planning Harper's Ferry. But the most significant response comes from a lawyer in Illinois. Abraham Lincoln is running for Senate. He reads Taney's opinion 3 times, makes notes in the margins, underlines the contradictions. On June 26, 1857, in Springfield, he delivered his response. "The Dred Scott decision is erroneous. We know the court has made it. We shall do what we can to have it overruled." The crowd gasps. "Overrule the Supreme Court? That's near treason." Lincoln continues, "If this decision stands, slavery will become lawful in all the states, old as well as new, North as well as South." The logical conclusion of Taney's reasoning is that no state can exclude slavery. The sacred right of self-government is denied. Popular sovereignty is destroyed. Stephen Douglas, his opponent, defends the decision. "The Supreme Court has spoken. All good citizens must obey." Lincoln responds, "When the Supreme Court denies the humanity of 4 million Americans, obedience becomes complicity with evil." Northern merchants, previously neutral, choose sides. New York's Chamber of Commerce, fearing Southern boycotts, initially supports the decision, but their customers revolt. Stores that back Taney see sales collapse. Signs appear. "No friend of Dred Scott shops here." By summer 1857, the North has effectively nullified the decision. No free state will return fugitives. No Northern court will recognize slave property. The Supreme Court has spoken. The North has answered, no. Charleston, South Carolina, March 7, 1857. Cannons boom from Fort Sumter. Bonfires light the streets. The Charleston Mercury prints a special edition, "The Triumph of the Constitution." Senator James Hammond of South Carolina declares, "The Supreme Court has vindicated the South. Slavery is now national. Freedom is sectional." In Richmond Inquirer editor Edward Pollard writes, "The highest tribunal has confirmed what we always knew. The Negro is property, nothing more. The abolitionists are defeated forever." Southern politicians celebrate. Mississippi, Senator Albert Gallatin Brown. "The Supreme Court has opened the entire continent to our peculiar institution. Kansas is ours. Nebraska is ours. Oregon is ours." Georgia's Robert Toombs goes further. "We can now demand protection for our property in every territory. The federal government must defend slavery everywhere its flag flies." But within weeks, the celebration sours. The first problem, enforcement. The decision says slavery is legal in all territories. But who will protect slave property in Wisconsin? In Oregon? Federal troops? The second problem, Northern defiance. Every Northern state has essentially nullified the decision. Southern property, human property, has no protection above the Mason-Dixon line. The third problem, Kansas. The decision was supposed to settle bleeding Kansas. Instead, free soil settlers flood in. They don't care what Taney said. They vote. They fight. They win. By October 1857, Kansas had rejected slavery in a landslide referendum. The pro-slavery Lecompton Constitution is defeated. The Supreme Court said slavery was legal. The people said no. Southern moderates realized the trap. Alexander Stephens writes privately, We have won a barren victory. The court has given us a right we cannot enforce. Worse, it has awakened the North to the danger we pose. Senator John Bell of Tennessee warns colleagues, "This decision will create more abolitionists than all of Garrison's newspapers combined." He's right. Republican Party membership doubles in 6 months. States that voted for Buchanan in 1856 are organizing Republican clubs in 1857. The economic consequences hit immediately. Northern banks stop lending to Southern plantations. Northern merchants raise prices on goods shipped south. Insurance companies increase rates on slave property. The Charleston Mercury, which celebrated so loudly, now complains, "The North acts as if the Supreme Court doesn't exist." The Fire Eaters, radical secessionists, see opportunity. William Yancey of Alabama. The North's defiance proves the Union is already dissolved. We should make it official. Robert Barnwell Rhett of South Carolina agrees. The Supreme Court has given us the legal right to secede. The North's refusal to honor the decision breaks the constitutional compact. But Southern Unionists are terrified. Sam Houston warns, "This decision has killed the Democratic Party. The Republicans will take power." Then what? The answer comes from the most unlikely source. Senator Stephen Douglas, Democrat of Illinois, announces the Freeport Doctrine in 1858. Territories can exclude slavery despite Dred Scott by simply refusing to pass protective laws. The South explodes. Jefferson Davis calls Douglas a traitor. Southern Democrats abandon him. The party splits. Meanwhile, Southern slaves hear the news differently. The decision denying them humanity spreads through the quarters. But so does Northern defiance. Escape attempts increase. Work slowdowns multiply. The peculiar institution becomes more unstable. A Virginia planter writes in his diary, "The slaves have heard of the Supreme Court's decision, but they have also heard of the North's response. They grow bolder daily." Southern militias expand. Patrol laws tighten. The cost of controlling slaves rises. By 1859, the victory had become a curse. The South has won in court, but lost in reality. They control the Supreme Court, but not Kansas. They have Taney's opinion, but not Northern submission. John C. Calhoun had warned years before. The South cannot win through law alone. Law requires force, and force requires unity. The Dred Scott decision has given us law, but destroyed unity. The Richmond Whig admits in December 1859, "The Supreme Court's decision has accelerated the crisis we sought to avoid." Then, John Brown raided Harper's Ferry. His last words before hanging, "I die knowing that Taney's decision has awakened millions to the sin of slavery." The South's Pyrrhic victory is complete. They won Dred Scott. They lost America. Illinois, summer 1858. 7 debates across the state. Stephen Douglas, the Little Giant, was defending popular sovereignty and his Senate seat. Abraham Lincoln, the prairie lawyer, made Dred Scott the center of American politics. Ottawa, August 21, 1858. 12,000 people in a town of 9,000. Lincoln rises, 6'4", and drives straight at the wound. Judge Douglas asks you not to care about slavery. He tells you it doesn't matter whether slavery is voted up or voted down. But the Supreme Court has said you cannot vote it down. Popular sovereignty died with Dred Scott. Douglas responds brilliantly, "Mr. Lincoln misunderstands. Territories can still exclude slavery by refusing to pass protective laws. Slavery cannot exist without positive protection." Lincoln pounces, "So you admit the Supreme Court was wrong? Either popular sovereignty is dead, or Dred Scott is illegitimate. Which is it?" The crowd roars. Douglas has walked into Lincoln's trap. Freeport, August 27, 1858. Lincoln asks the question that will destroy Douglas. Can the people of a territory exclude slavery before statehood, despite the Dred Scott decision? Douglas gives his famous Freeport Doctrine. Slavery cannot exist without local police regulations. The people can exclude it by refusing to pass such laws. The Northern Democrats cheer. The Southern Democrats rage. Douglas has just split his party to win a Senate seat. Lincoln smiles. He's lost the Senate, but won the argument. Douglas can't have it both ways. Either obey Taney or defy him. Choose. Jonesboro, September 15, 1858. Deep in southern Illinois. Pro-slavery crowd. Lincoln adjusts his strategy. I am not arguing for Negro equality. I am arguing against the spread of slavery. The Supreme Court says slavery is national. Judge Douglas says it's local. Both cannot be true. He reads from Taney's decision. The right of property in a slave is distinctly and expressly affirmed in the Constitution. Then he asks, if this is true, how can any territory exclude it? How can Illinois remain free? The next Dred Scott decision will force slavery on every state. Douglas deflects. Mr. Lincoln opposes the Supreme Court. He would destroy our institutions. Lincoln responds, when the Supreme Court decides that 4 million Americans are property, the institution has already destroyed itself. Charleston, September 18, 1858. Lincoln makes his constitutional argument. The founders expected slavery to die. They banned it from the Northwest Territory. They allowed Congress to end the slave trade. They believed in ultimate extinction. Taney has reversed the founders. He makes slavery eternal. Douglas attacks. Lincoln would make war on the Supreme Court. Lincoln's response echoes through history. I do not resist the decision. I resist it as a political rule. If this decision stands as doctrine, if it becomes settled policy, then slavery will become lawful in all states. We shall lie down pleasantly dreaming that Missouri is free and wake to find slavery legal in Illinois. Galesburg, October 7, 1858. Rain and wind. 20,000 people stand in mud. Lincoln connects Dred Scott to conspiracy. When we see a lot of framed timbers, different portions of which we know have been gotten out at different times and places by Stephen, Franklin, Roger, and James, and we see these timbers joined together into a house, we find it impossible not to believe they all worked upon a common plan. Stephen Douglas, Franklin Pierce, Roger Taney, James Buchanan. The conspiracy to nationalize slavery. Douglas is furious. Lincoln sees conspiracies everywhere. But the crowd understands. The timing was too perfect. Buchanan's pressure on justices. The broad decision was beyond what the case required. The pieces fit. Quincy, October 13, 1858. Lincoln makes his moral case. Judge Douglas says he doesn't care whether slavery is voted up or down. I say the real issue is whether slavery is right or wrong. The Supreme Court has said it's right. Constitutional, protected, sacred. I say that decision is wrong. Alton, October 15, 1858. The final debate. Lincoln's climactic argument. That is the issue that will continue in this country when these poor tongues of Judge Douglas and myself shall be silent. It is the eternal struggle between two principles, right and wrong, throughout the world. The one is the common right of humanity, the other, the divine right of kings. It is the same spirit that says, you work and toil and earn bread, and I'll eat it. No matter what shape it comes in, whether from the mouth of a king or from the mouth of the Supreme Court, it is the same tyrannical principle. Douglas wins the Senate seat. Southern Democrats ensure that, but they mark him as unreliable. He will never be president. Lincoln loses the election, but wins the future. His published debates sell 500,000 copies. Republicans nationwide adopt his arguments. The Dred Scott decision has become the Republican Party's greatest weapon. Every Republican candidate in 1860 will run against Taney. The decision meant to save slavery has become its death warrant. Lincoln writes to a friend, "I am glad I made the race. It gave me the chance to put the moral question before the American people." Dred Scott has clarified everything. We cannot be half slave and half free. The Supreme Court has forced us to choose. And we will choose freedom. May 26, 1857. 2 months after the Supreme Court declared him property with no right to sue, Dred Scott walked out of the St. Louis courthouse a free man. No headlines this time. Calvin Chaffee, the abolitionist congressman who discovered he'd married Dr. Emerson's widow, making him technically Dred Scott's owner, frantically transferred ownership back to the Blow family. Taylor Blow, whose father Peter had owned Scott as a child, quietly filed the manumission papers. The fee? Nothing. After 11 years in court, freedom comes through embarrassment and paperwork. Scott takes a job as a porter at Barnum's Hotel in St. Louis. Guests sometimes recognize him, the most famous slave in America, now carrying their bags for tips. He tells visitors he holds no bitterness. September 17, 1858. Barely 17 months after the decision, Dred Scott dies of tuberculosis. The newspapers give it 3 lines. Harriet follows within a year. Their daughters, Eliza and Lizzie, disappear from the historical record. Roger Taney lives on. From his Supreme Court chambers, he watches his decision detonate across America. October 16, 1859, John Brown raids Harper's Ferry, citing Dred Scott as proof that peaceful change is impossible. May 1860. The Democratic Party splits at Charleston over the decision's implications. November 1860. Lincoln wins the presidency without a single Southern electoral vote. December 20th, 1860. South Carolina secedes, citing the North's refusal to accept the Dred Scott decision. April 12, 1861. Fort Sumter falls. The war that Taney's decision helped ignite began. The 82-year-old Chief Justice watches President Lincoln suspend habeas corpus, raise armies without Congress, and ignore Supreme Court orders. When Taney issues ex parte Merryman, declaring Lincoln's actions unconstitutional, the president simply ignores him. The Supreme Court, that once declared itself supreme over Congress, finds itself powerless before executive war powers. Taney writes privately, "The supremacy of the military power seems to be established." January 1, 1863. Lincoln signed the Emancipation Proclamation. 3 million enslaved people declared free by military order, exactly what Taney said no branch of government could ever do. The Chief Justice, now 85, confined to bed, rages impotently. His own state, Maryland, abolishes slavery while he still breathes. October 12, 1864. Roger Brooke Taney dies in Washington. The Senate refuses to commission a bust in his honor, the only Chief Justice so dishonored. Lincoln appoints Salmon P. Chase, an abolitionist, to replace him. Chase's first major act, admitting John Rock, a black lawyer, to practice before the Supreme Court. The symbolism is intentional, brutal. April 9, 1865. Lee surrenders at Appomattox. 750,000 Americans are dead. The constitutional crisis Taney claimed to solve forever has been settled by artillery and infantry. December 6, 1865. The 13th Amendment is ratified. Neither slavery nor involuntary servitude shall exist. Taney's declaration that black people were property is erased from the law. July 9, 1868. The 14th Amendment is ratified. All persons born or naturalized in the United States are citizens. Every single word of Taney's opinion is now explicitly unconstitutional. The amendment's framers quote the Dred Scott decision repeatedly during debates as the evil they're destroying. Senator Jacob Howard declares, "This amendment will overturn the Dred Scott decision and make citizens of those whom that decision declared could never be citizens." 1872. John F. A. Sandford, the defendant who gave his name to history's most infamous case, has been dead for 15 years in an insane asylum. His name was actually Sandford. A court clerk's spelling error immortalized the wrong name. History's bitter joke, the case that tore America apart, got the defendant's name wrong. 1957. 100 years after the decision, Dred and Harriet Scott's great-granddaughter sits in a federal courtroom in St. Louis. She watches 9 black students win the right to attend Little Rock Central High School. The Supreme Court that once declared her ancestors non-citizens now orders federal troops to protect black children entering white schools. Today, law students study Dred Scott in constitutional law classes as the court's greatest self-inflicted wound. It stands as eternal proof that Supreme Court decisions are not always supreme, that when the highest court in the land declares evil to be law, the people can and will overturn it, no matter the cost. Chief Justice Charles Evans Hughes would later call it the court's self-inflicted wound that almost destroyed the nation. The decision's only monument is negative space. The amendments erected to destroy it. The precedents overturning it. The universal agreement that it represents the worst decision in Supreme Court history. Dred Scott sued for freedom and lost. But his loss was so absolute, so morally grotesque, so constitutionally untenable, that it forced America to finally confront the original sin it had been avoiding since 1787. He didn't live to see it, but Dred Scott's defeat in court became freedom's greatest victory in history. Sometimes, losing a battle so completely that conscience can no longer tolerate the result is the only way to win the war.